We've got it's about 170 pages summary, which we can share with anyone who wants, of just the procurement chapter. So let's kick off. So welcome to Dr. Allison Anthony, and thank you for joining us. Senior Lecturer of Public Procurement Law and author of Construction Procurement in South Africa. So there's the book. I bought 2 copies. One that we're going to give away to someone who's online at the end of the session today. So I have started working through it. Of course, books like this you don't necessarily read as you do a novel. You dive into chapters as might be necessary, but
it's not bedtime reading.
It's not. and it keeps me awake. It does. But Alison, before I let you off, one of the things that I was really interested to see you contribute was the Administrative Justice book, 2nd edition, that came out. You also contributed to the 1st edition. And I would love to be able to get you on at some point in time to talk about your specific chapter, which was lawfulness.
Lawfulness, yeah.
And together with Prof. Gio. So welcome. Now, I said you are Senior Lecturer of Public Procurement Law. Is that still the case?
Yeah, that's still the case. I'm also involved at the African Procurement Law Unit as Deputy Director, together with Gio Kino and Shope Williams-Legbe.
Fantastic. But you're not going to be doing much lecturing this year, are you?
I hope not. Let's see.
Where are you going to be? You told me something about some travel plans that you've got.
Yeah. So thankfully, Omicron has proven to be less severe as we thought initially. Thank goodness, because this has been a project that's been in the running since 2019. I'll be doing some research at the George Washington University in Washington, D.C., focusing on construction procurement in Africa, and also from an international perspective as well. So I'm keen to learn from those guys over there.
You'll be at the Public Procurement Law Unit. Is that right?
Yes,
is that so very, very specific?
Well, they call it government procurement.
Government procurement in the US, yes. That's right. And I think they've got a big webinar coming up quite soon about their Buy America in infrastructure.
Yes, yeah. I'm very curious about that.
Well done on your book and getting it out. And
Thank you.
And sincerely to all of those online, if you do not have it, where would you go if you wanted to get the book?
Okay, so the best and the easiest would be on the JUTA website. You can literally Google Construction Procurement Law in South Africa, JUTA, and it'll come up.
And I found them very quick.
Yeah, they are quite efficient.
In fact, the 2 books cost me nothing from a delivery perspective. So.
Okay, wonderful.
And it is very, very reasonably priced. Alison, how did you get that right?
So this was a discussion between JUTA and myself. And I said to them, I really, the goal is not a money-making thing at all. Knowledge should never be an economic endeavor.
Yeah. Sharing
of knowledge. I feel the same way about people doing PhDs. No one should ever have to pay for a PhD. No one should ever have to pay, an arm and a leg for new knowledge and information that's so needed and affects all of us. So I was very adamant about that and just said, it has to be as affordable as can possibly be, to obviously not to the extent that JUTA suffers in the process. But yeah, we were able to do that because I thought, it's something that as many people as possible should have access to.
Well
it's
done.
Something that, when you buy a book, the first thing, especially an academic book, the first thing you worry about is, gosh, how much is this going to cost? So I think people have been very surprised to see that it's a very affordable price at 295 Rand.
Excellent.
So that was the aim behind that.
And it is not onerous, actually. So it is not very thick, but it is. I found it quite comprehensive. So thank you for that. May I ask you, why did you write the book? Why did you decide to do it?
Okay, so the book didn't start as a book. It's a combination of work done during my master's and doctoral theses and afterwards as well. And I found when I first started reading up about this, when I wanted to do a master's degree, my supervisor then, Phoebe Bolton, said, she threw out a couple of topics and she said, read about this, read about that. And one of the topics was construction procurement. And I came back and I said, well, you know, there's absolutely nothing on this. And I saw it as an opportunity. Yes, it was intimidating at first because you like to rely on, you know, your authorities and just take it from there. But I saw it as an opportunity because here's something that's never been written on, at least from a legal perspective. You know, if you Google construction procurement, you'll always find from an engineering perspective, a little bit from public administration, but nothing from law. So that was a serious gap because as I read about it, everything was in engineering jargon, as I put it. And I said, well, you know, if something happens here, if this goes to court, who deals with it? We do as lawyers. And why don't we understand why isn't there a law for construction procurement? And I discovered that there are laws, it's just not comprehensively put together. And that's where the idea of the book came from, you know, sort of a comprehensive construction procurement law or the law that regulates it. You'll see that my M&D thesis topics are also the legal regulation of. So as to convey that construction procurement is a part of the law and it's regulated in a particular way, just like any other part of the law is, just like human rights, like contract, delict, anything else. And so this was a need and a gap, a huge vacuum. I'm not aware of anything else in Africa to this effect that's been done. I may be wrong, but hopefully it will inspire others as well to really, you know, dig in, and because that's what I had to do at the beginning, dig into all the engineering jargon and the construction talk and figure out where is the law and how is and should it be regulated? You know, what are the issues that we're facing here so that we can get better regulation in Africa as a continent and not just South Africa because we don't exist on our own.
Thanks, Alison. So I've got a couple of questions that I ran past Alison. I'm just going to run through those. If anyone has questions, please pop them into the chat straight away, or you can hold them and we can get the discussion going a little bit later. So, Alison, from a procurement law perspective, we've got the Constitution 217, and it says very clearly that when an organ of state contracts for goods and services, it must do so in accordance with the system. The goods and services, it doesn't say anything about works, infrastructure, or procurement. You've written quite a bit about that. Is construction and infrastructure included under 217?
In my view, yes, absolutely. It just says one of my recommendations that I've always had is that the Constitution should read when government contracts for goods, services, and works. Works, into my mind, is a combination of goods and services. A lot of people say one of our recently departed authors, Stephen Delahaye, said that there's no need for works to be included because it is a combination, and here we have goods and here we have services. But I argue that we actually do need that distinct category of works because it's special in that it's a combination and it's dealt with a little differently than you do goods on its own and services on its own.
There have been some case law that have also confirmed this. Is that right?
Yes, in my mind, not explicitly, but yes, the implication is there.
The Imperial AXA was one of those.
Yeah.
And I think there was one other as well. And okay, so by the way, is there a difference between construction and infrastructure?
That's a very popular question that I get all the time. in my mind, from a legal perspective, yes. I think when you look at National Treasury and all the instruction notes and the rules that they publish, the intention was not to create two different systems. But legally, what has happened in using the terms construction procurement for certain rules and infrastructure for others is that it's created a parallel system. And those things don't align. So from a legal perspective, they are two different things. Construction procurement is defined in one way in the CIDB Act and its regulations, and infrastructure procurement is defined in a different way. And when you go into the nitty-gritty of those definitions, some of the goods, services, works that are covered in the definition of construction procurement are not covered in infrastructure, and vice versa. So that is why I say those two are two very different things. I do believe that the intention was that infrastructure is an umbrella term and that it was intended to cover construction procurement as well. But from a legal perspective, that is not exactly what it does.
So where would one go then for a definition of each of those? So you said construction, go ahead.
Yeah, so for construction procurement, you would go to the CIDB Act and its regulations, the latest regulations. I can't quite remember, so please don't quote me on this. I think it's 2014, could be later, but the book has the updated date of the latest regulations. And then in your infrastructure procurement, that would be your FIPDM, for the Framework for Infrastructure Procurement and Delivery Management, that has a definition of infrastructure procurement. I also argue, you know, what is the difference in the legal nature of these documents? On the one hand, we have construction procurement that's regulated by an act, a promulgated act and its regulations. And then you have infrastructure procurement, which is regulated by rules and instructions that are published by the National Treasury. Now, they are given that power to do so in Section 76 of the Public Finance Management Act 1 of 99. But there is a paper where I make an argument where I say that it's actually the Construction Procurement or the Construction Industry Development Act, CIDB Act, which to my mind, in a hierarchy, if we had to have a hierarchy, it would go higher on the list than instructions. Yeah. But there's an entire argument behind that. I'm just superficially mentioning that.
Right. But it's an important distinction and important for us to understand. Now, you mentioned the framework for infrastructure delivery and procurement management, FIDPM, and then there's also the standard for infrastructure procurement and delivery management. So those two originate under the PFMA and MFMA. I think the one is still applicable under MFMA and the other one is applicable under PFMA. So those originate from there, and it's subordinate law on that side of, and then we've got the construction on the other side. Now, if I'm a practitioner and I need to figure out where do I go, what rules do I follow, any thoughts on that? Any thoughts to guide how one would go? I mean, I need to do a guardhouse at the gate. I need to do some infrastructure. I have to do a laboratory. Any thoughts?
Sean, that is a difficult question that I actually don't have the answer to. Empathize with people on the ground, people at the grassroots levels who have to deal with these rules, because that is the question at the end of the day. Yeah, you have essentially two sets of rules. Which one do you apply? Yes, the one is legislation, the other instructions published in terms of legislation, but then also Big Brother watching us, the AG. And that's what people are afraid of. If you don't comply with your rules published by National Treasury, what will the effect be in your audit? So I think practically it would probably be a matter of trying to amalgamate those, because at the end of the day, the goal is compliance with Section 217 of the Constitution, not deviating from those five pillar principles. That would be how I would see it. Practically, you would have to ask a practitioner how they actually manage it on a day-to-day basis. I don't want to assume how they do that.
And I know there's some folk online that would actually maybe want to participate in this one, but if you come to the practicalities of the distinction between infrastructure and construction, is the guardhouse construction and the research facility infrastructure? I don't know. Is there any thoughts, or is this part of the I empathize point?
It is part of it. Yes. And
Okay.
for somebody to comment on how they deal with that, because I about it as well.
I see that there's some people online with some big infrastructure projects behind them, so maybe they will come in on that point. You've got a chapter on preferential procurement in your book. I think it's chapter 5, and you talk through that. Now, big uncertainty for everybody around the Constitutional Court's deliberations on the Supreme Court of Appeals decision. Well, firstly, I mean, in this uncertainty, you were courageous to put in a chapter on preferential procurement. But any thoughts on what there might be in the CIDB side of things? Any thoughts on where on what you are hoping the Constitutional Court will actually decide on?
Sean, I haven't read the judgment in a while. Sorry, I just have a student calling me. Sorry about that. So I would have to look at the judgment in detail to give you a detailed feedback.
Okay, so there's no judgment on the Constitutional Court side yet.
Yes.
Right,
I'm talking about the SCA.
Right.
Yeah, sorry.
Right.
So in terms of, I'm looking at the SCA judgment in terms of your question, what I would like to see the Constitutional Court decide. There are 2 things that I took issue with in the SCA judgment. The first and most pertinent one is probably the fact that the entire set of regulations was declared invalid.
Right.
When certain of them were impugned, actually. So I think that is a legal issue that the Constitutional Court should set straight, that it should correct. It's not necessary to, strike down an entire law if parts of it can be removed, and if parts of it don't comply with the main act. So that is what I would like to see corrected. I would also like to see the thinking behind how to deal with pre-qualification. Where the court says that pre-qualification actually goes against Section 217.
The framework, I think it said it goes against the framework.
Yeah, the framework of 217. I struggle to understand why the court said that. I don't see a problem legally with a pre-qualification. The fact that there's double dipping in the triple PFA is a different story.
Yeah.
Dipping in the sense that you can pre-qualify based on preference and then award preference again in the system where you award your 10 or 20 points. That is double dipping. That is something that can be challenged and be seen to be ultra vires. But just the concept of pre-qualification is something that I think the court will need to rethink. In how far it offends against the framework of Section 217. Remember the specific goals and what you can actually claim preference for in those 10 and 20 points. It's extremely limited. You're basically limited to your BEE scorecard. And I don't think the intention was in the Act to limit it only to that. I think it also limits if we move away from just the legality. I don't think the intention was to limit the creativity that could take place, the innovation that could take place in the award of preference points. An example is in the CIDB situation where things such as set-asides and many of those that I mentioned in the preference chapter that previously were used but are not now allowed because of the triple PFA and its regulations. it worked.
Mm.
And it work in other industries as well. And it allows for the nuances of the specific sector. So I think that is something that should be rethought in its entirety. Perhaps not move away from a point system, but what can be, what points can be awarded for, and how that is calculated could be reconsidered in my mind.
Interesting. So we'll certainly be watching that and see what the Constitutional Court says, hopefully soon.
Definitely. Everybody's waiting with bated breath.
You wrote your book at a time when there's a lot of discussion around the Public Procurement Bill. And that is intended to be enacted, as far as National Treasury is concerned, in November this year. Not too sure, but anyway, it's on the way, and it's been drafted. In the draft that was issued in 2020, it clearly stated, which is one of the big issues, that we want to try and do away with this very fragmented legislative environment that we've got. But that draft still kept public procurement and infrastructure, and has a whole chapter on infrastructure, but didn't do anything about CIDB.
Yeah.
What are your thoughts on that? Do you think it should have gone further and actually done something about consolidating CIDB into it, or what are your thoughts?
Sean, I was very, very surprised to see only 2 or 3 pages on infrastructure or construction, whatever you'd like to call it. And I do think that they should have delved in further and said, you know what, throw the kitchen sink at it almost, and say, construction procurement is part of procurement. It falls under Section 217. There should have been a lot more detail. I don't know what the absence thereof, what the reason is for that. Maybe it's not having the knowledge or the expertise to write something more detailed, but that is not an insurmountable obstacle. So I would like in the next draft to see, I've also written a paper on this in the African Procurement Law Journal, on what I think should be included, and those were more specifically preferencing issues, which is of course the most important thing at the moment. This whole definition issue, because a lot of people may think it's a lot of semantics, it's just, another lawyer saying a lot of things about different definitions, but it actually has a lot of legal consequences, because when you get to a court, which definition would apply? It's all about language. In a court of law, and those judgments are what give us guidance on how to deal with those rules in future and how they should be interpreted. So it informs our practice of construction procurement, and that's why it's important to go back to the drawing board and say, well, how do we define this? What are the categories of services, goods and works, whatever you want to call it? What are those? What does it fall under? What do these things constitute? Does it constitute construction? Does it constitute infrastructure? Is there a difference? Should there be a difference? Where are the anomalies? So I think that is an important thing. That would probably, to me, be, where you start off, is sorting out that problem first. And then you can go further and say, well, what do we want in regulating construction procurement? What is our goal and how are we going to get there? So that's what I would like to see in the bill next time, a lot more detail, and addressing pertinent issues that we've had previously, like conflict of laws, CIDB versus PFMA, laws and regulations versus instructions. And I think, something that frustrates me often, I always say, many cooks spoil the broth, and that's what's happened, in my opinion, in construction procurement. The CIDB has been given a legal mandate in the CIDB Act to regulate this sector. But I think much of it has been taken out of their hands by National Treasury. And at times it may have been necessary, but I think perhaps, too many cooks have spoiled the broth a little.
Interesting. I've got one more question, and then we're going to open it to the floor. And I see there are a couple of points that are being made. The construction mafia is something that's often discussed. But what about the Commission of Inquiry into State Capture, the inquiry into state capture and its recommendations? Any thoughts on the recommendations that are included there? I don't know if you've had a chance to look at it.
Well, I haven't read the report in detail. I read it every couple of days when I have an open space. I've had a look at the recommendations, and I tend to agree with them. I think they're thought through, very detailed. So I would like to see that a lot of them are implemented and that they're put in the procurement bill as well, because I think it would go a long way in not only preventing some of the corruption, but also fulfilling the goals in Section 217. Things such as transparency, for example.
Interesting. They talk about this corruption agency as well. In the Public Procurement Bill, they talk about the regulator, which is going to be inside Treasury. Do you think that's maybe giving some insight as to maybe those bodies coming together, maybe, or?
Sean, I'm not in favor of the regulator sitting in National Treasury. I would like to see the regulator as an independent body. Somebody that is free of any type of mandates that they might have alongside the mandate for corruption, preventing corruption and regulating public procurement. I think that would also make it more focused and independent. I think that's an important thing, and the transparency.
And further supported by the Zondo Commission's recommendation about this independent corruption agency into public procurement.
Yeah, it's that independence issue that should consider.
Those might come together. Okay, so any thoughts? Let's open up. Thanks very much, Alison. Thank you for that. And
Ron,
hello, Ron. Welcome.
Just to thank Dr. Allison for attending and for her superb contribution at a NOJASA conference we were both at, where she gave a seminal input, I felt, on what constitutes legislation, and of course that's critical for our understanding of irregular expenditure. And the sense I got from the conference is that everybody was very supportive of her approach, and even Julie, the ex-public protector, mentioned publicly that she had erred, after listening to sort of, Alison's talk, on this matter. So thanks for leading the charge, Alison, in terms of, what constitutes legislation and therefore a breach of legislation for the purpose of this. Just three brief comments. The one is, Sean, you started at the beginning by saying there is a summary of the state capture which will be made available. I'd like to request a copy. Secondly, we asked National Treasury about the new date, if the date had changed for the proposed date for the procurement bill, and they confirmed the date's now been moved to early next year. It seems as if it's now around about March next year. Thanks, Sean.
Thanks, Ron.
Yeah, I think that's also why the book has taken a while. Well, people obviously won't know behind the scenes how long it's taken for the book to actually get out. And it's because of all the changes in the law, actually. First, we had the standard, and then we had the framework. And, I had to take a step back and told Jutta, you know what, this might change some things I've written. I need to rethink this and rewrite and reread. And then the bill came, and I decided, you know what, the law is a living thing, and it's ever changing. And construction procurement as well. There's always going to be a new law, but this is the situation at the moment. And that's an example that we have right there, you know, that the public procurement, just at the beginning of the talk, we thought it was November this year. Now it's March next year. So yeah, you can't always just wait for change.
I expect also, Anthony, that Alison, that the Commission of Inquiry into State Capture is going to have an impact and influence on the Public Procurement Bill.
I would hope so, yes.
And they may need to think about lots of things, rethink about lots of things.
Yeah.
Interesting. So also just reflecting on that, Ron, France, I see your hand. If it's enacted in March 23, it's still going to be later in 23 that it'll be effective. So we're still a long way away from actually that. Yeah, a long way. We're going to have to live with what we've got for a long time still.
Yeah, Sean, you mentioned my name. There's a problem with National Treasury's, enacting whatever they call it, circulars, instruction notes, etc. They actually have recently they've changed. The last 6 months have changed, but generally they do not allow sufficient time for change management. We've had very harsh examples of them making stuff immediately applicable, and that's had a major impact on our processes because it's legally impossible to do things immediately. You've got systems, policies,
governance,
training, governance, a whole lot of different things. But there is something I do want to emphasize, and this point just amplifies it. What most practitioners may not be aware of is that there's actually a two-stage consultation process. So we've gone through the first stage, but the second stage is once it goes through Parliament, it gets opened up again for consultation. So obviously the version that's submitted to Parliament will hopefully take into account all the comments. But if it doesn't take them into account appropriately, or it raises new problems, I would really encourage everybody to go through the process they went through again, and then provide their comments to Parliament, in the consultation that will and should be afforded us. Thanks, Sean.
Thanks, Ron. France, would you like to come in?
Good morning. Yes. Good morning, everybody.
Sorry, France. Let's just ask Alison to respond to that first, and then.
Sorry for interrupting. Just a quick comment. I think Ron used the word enact, and I think it's publish. So National Treasury publishes, but the legislature enacts. So I mentioned that because that distinction is important, because it has a legal consequence.
So they would enact the bill. They publish their instructions.
Yes.
Right. Go ahead, France.
Okay, good morning, everybody. All of the best for 2022. I wish all is going to be an exceptionally good year for everybody. Thank you, Dr. Allison, also for sharing your insights. My sentiment with regard to the whole dispensation that we are in, and we've seen 2 years of almost total inaction, and many of the bodies that one would expect to discuss this not actually formally meeting or in any way meeting and engaging. My sentiment is that we shouldn't wait for the procurement bills and legislation to be done by Treasury or by anybody else. I think we as professionals should proactively get together, and in this instance I talk specifically about the built environment professionals under the CBE, who was supposed to be led by the CIDB, who has not been functioning for too long, that we should get together. And in one of the first sessions of this forum that I attended, I made a suggestion, and I still have that thought very strongly, and it's getting stronger, that the procurement dispensation should be developed by each industry for themselves. Because that is the best way that the needs of that industry can be addressed and fully recognized. If you go back to the current situation where we've got all the SBD forms, etc., in the tender submission document, most of them is irrelevant to us in the built environment. and I don't even include there the property industry, where the sale and disposal of property comes in. You know, I absolutely like that we're talking about this, but we need to move towards putting something on the table before government starts their processes, and put something on the table that ignores what we in the industry know should be happening. So my recommendation is, let's mobilize and get these thought leaders around the table and do the right thing and develop these policies and procedures from bottom up. I do think it will be the most valuable input or initiative that we can do to the benefit of the industry, because then it comes from where it should be, instead of being imposed from above. It needs to be done. It really, you know, I look at many tender documents, and the sad reality is very few of them actually capture what is necessary or what the party that is putting it to tender actually wants to achieve. If you look at the many forms that gets regurgitated and so many problems on those, and the scope of works, which is the most critical aspect of the full document, may receive a couple of paragraphs. Though it needs to be done the other way around. Your scope of work should be the core. Your person that is submitting the bid should know what is expected. Let's talk about that and mobilize, and I think develop something of value to the industry. Thank you.
Thanks, Frans.
I think, Frans, there have been attempts to do that in the past. I think for some industries, it really is the way to go. There have been many talks between CIDB, National Treasury, etc. I think the reticence on industry's part is that it's been done in the past, and then rules are enacted or published, or whatever we want to call them, which negates what's been done. And it takes a lot of time and effort, you know, a lot of will, a lot of wherewithal to put down what industry wants for it to just be completely almost ignored by the powers that be. So I think that is the reason for the hesitance, but it really is what should be done, is that industries should rise up and say, you know, we are the people that deal with this on a daily basis. We are the people that have the need. When it comes to procurement, you know, identifying the need. We know what we want at the end of the day, and we need to comply with constitutional imperatives. So let's get together and see how we can do that so that we still comply with 217. How we can correct that? Yeah, that is something we need to brainstorm and think about.
I mean, there are some real industry experts that have provided input. Do you know if CBE, for example, provided input on the draft Public Procurement Bill?
I'm not sure.
Or if there was an industry body, that would be an interesting one.
I'm not sure at all. I know that as APLU, African Procurement Law Unit, we delivered an opinion, well, not an opinion, an input.
Feedback,
as well.
Yeah.
I know that the ASIQS made a submission, and the SICQSP from the quantity surveyor side. However, you know, when I looked at the document, I said it's not really worth commenting on, with all due respect to whoever developed it, because they totally, as an example, ignore technology and e-procurement. As an example, I mean, we're going towards the 5th industrial revolution, not back to the 1st. So we need to be proactive. So my sentiment and thought to the committee in the first meeting that we engaged was they should be encouraged to do exactly what I mentioned earlier. Let the industries develop this document rather than a blanket one. The blanket one should be a general document that all refer to, and it should obviously cover the constitutional requirements and references to other acts and all of that, but the industry should develop it internally. That document was so vague, and which added to the concerns at the time was Afrisaka's case just came up, and it was then just also announced that you know, the whole process is going to be referred back. So we don't even know where the existing one is coming up. And reading from the state capture report, I have no doubt that there's going to be recommendations. So back to my sentiment, we as industry should monitor what is stated with regard to our own industries in that report and not wait for government to take the lead. We should do that.
Thanks, Frans. Esmeralda Isaacs, welcome. Love to hear from you, Esmeralda. Go ahead, we can hear you.
Good morning, esteemed colleagues, Sean, Dr. Allison Anthony, Ron, Grace, and all the very important people. So my name is Esme. Everyone knows me as Esme in the SCM fraternity. I'm from Health in the Western Cape. Sean, I would just like to add one thing. I completely agree with what Frans is saying, but there's just one thing that we need to mobilize and that we need to work towards in order to sort this thing out once and for all. So if we do have the CIDB Act, why can't we strengthen the CIDB? Why can't we lobby for infrastructure procurement that's been taken hold of by the National Treasury to be moved to its rightful place? Then the processes of merging and then the supply engagements can start happening and be taken up in more earnest, because currently we're just one of many things. Or see, construction and infrastructure is just one of many things that the National Treasury should keep an eye on. But there's a complexity and a uniqueness to construction/infrastructure procurement, and it's highly complex. And I think that's maybe one of the reasons why the CIDB was established, to specifically move into that direction and to strengthen that part of our procurement system. But I think an anomaly started happening when the National Treasury started doing the same, or putting in regulations as well on something that's already legislated by, CIDB. And I can understand why the CIDB is not fully functional, because what should they be doing and what should they not be doing? What if they put out something and it's negated by the Treasury the next round? And unfortunately, the levels of understanding is not always the same in both entities, if I can put it that way. So if we need anything real to happen, which can take the procurement fraternity forward and also make it easier for the poor practitioner on level 8 and level 7 who's got to get a guardhouse, who's got to build a cold room, who's got to do all those funny and doesn't even know, if I don't even know as a chief director, how on this earth can I expect a level 7, a level 8, a level 9, the normal procurement guys to even understand it if we are still grappling with it. So I think you need to fundamentally we have to get that, I almost want to say, political will for procurement. You have to bring in that will to try and do things right from the bottom, from the root, from where it started. And then from there, all of those developments and things can take place. But because it does not make sense to me that the National Treasury is directly involved with that, when it comes to construction procurement. When it comes to 16A procurement, then I can understand. Obviously, it's the PFMA, flows from that, does make huge sense. But when it comes to construction and infrastructure procurement, then the type of service that you then get from the National Treasury is as if we are just another add-on. And that's a key problem, because infrastructure procurement provides, it's key to the economy. It supports our economy. We need to get that right. And we're not getting it right at all. And it's jobs and all of those things that's impacted. And all departments You can go to any department. They'll tell you how they struggle with infrastructure, construction, procurement, never knowing whether what they've done is right or not right and things like that. So thank you so much, Sean. Thank you so much for that. Thank you, Alison, and the rest of the guys. Thank you.
Thanks, Esme. We'll engage some more. Go ahead, Alison. Do you want to respond to that?
Yeah, thanks so much, Esme. You make some very good points. I agree with you wholeheartedly. You know, that it's no wonder that people at the grassroots don't know what's happening, because at the top, you know, I don't think people are really sure what's happening either. And that's the point I made earlier, that the CIDB is the one with the mandate. How it came to land in the hands of National Treasury, I'm not sure. I don't know what the process behind that was. But, you know, it's time to bring it back. Because the system as well, it was working for the larger part. It was efficient, was effective. So yeah, we should go back and reclaim it.
Alison, do you think that we may be better positioned if the infrastructure section in the Public Procurement Bill is taken out? And we don't confuse the Public Procurement Bill with infrastructure-related issues. And so if someone like Esme is sitting in the Department of Health, you know, she clearly then would be able to distinguish what the commodity is. And if it's construction or infrastructure, she goes CIDB. And if it's PPE and other stuff, she goes public procurement.
No, I don't think that's going to be helpful, because I wouldn't go that way, because it's important to still realize that construction infrastructure is procurement. And it's 217, and it's affected by other procurement legislation as well. It's also to change the thinking around construction procurement, because, you know, people are very territorial. Engineers believe, no, this is our sphere. Accounting believes, no, this is our sphere. Lawyers believe, no, this is our sphere. You know, so by putting it there, we acknowledge that it is an interdisciplinary aspect of the law, and of, you know, it affects all those areas and all those role players. And that's why I can't remember who it is that used the metaphor of chains. You know, we have all these interlinking chains. It's not just a checkbox. So by putting it in the Public Procurement Bill, we're saying, yes, this is procurement. It belongs here, and it belongs under Section 217. And it belongs to all of us. And we are all responsible for seeing that this runs smoothly and that it complies with Section 217. Lawyers, construction experts, architects, surveyors, everybody, because we're all interlinked in the system. And I think taking it out might create the impression that it's a construction thing entirely, which I think has been the thought up until now. And perhaps people start looking at it differently when they saw that it's addressed in the bill. So I think it should change. And perhaps that also taking it out will also not change the conflict between construction versus infrastructure. So I think that is where the essence of the problem lies. Fix that, put it into the Public Procurement Bill, and then move forward from there.
Good points.
Can I comment briefly?
Thanks, Ron.
Sean, I have commented briefly in the past that the CIDB appears to be vastly superior to their processes if we compare it to how National Treasury does things. They seem to be a centre of excellence versus, you know, I don't want to use terminologically publicly. Sure. National Treasury use it. But as we've been having a discussion, it's planted another seed in my mind. You know, we, for example, at the NRF, have centres of excellence, and it's a particular process. And generally with a centre of excellence, you fund excellence on the basis that you will get results. You're not necessarily going for the results, you're going for the team and that they will produce. And, you know, based on the structure in South Africa, it seems to me that there is a vast gap regarding infrastructure. So if we just simplistically regard construction as a part of infrastructure, then the main heading is in infrastructure. Okay, so we've had considerable attention and excellent attention given to construction, whereas in fact at the high level we should have that given to infrastructure. And, you know, by putting it in a regulator or national treasury, etc., I think it's going to make it worse, not better, because I don't think CIDB is going to go away. So it then begs the question, shouldn't then, you know, CIDB then be upgraded, that they are re-engineered to actually become, you know, responsible for the category of infrastructure? And I think they're incredibly well placed to do that. And then, you know, all these conflicts then sort of disappear. Thanks, Sean.
Alison?
Irrespective of which way it goes, it's about, you know, aligning it. Whether we're going to call it infrastructure, whether we're going to call it construction, it's about taking away the conflict and the anomaly, and make it, aligning all of it, and decide on one term, construction or infrastructure. But I think there would be more work to do if we had to change it to infrastructure, because all the legislation refers to construction. Perhaps just change the definition that falls under construction. You know, and construction is what has been used this whole time, and it's worked up until now. Infrastructure is the new term, and that's what sort of put the spanner in the works. Or include the definition of infrastructure and say that it's what we refer to when we talk about absolutely everything, but then be very careful when using the terms. You know, distinguish them and say, this is what construction is, this is what infrastructure is. The easiest in my mind would be give the CIDB its mandate as it has in legislation, and place what is currently under infrastructure within the construction procurement legislation as it is at the moment.
Thanks, Alison. Frans?
Yes, I would like to start where Alison ended off by, and I fully agree with what Esme said as well, and with some of what Ron said. I think what comes out is that the industry, whatever we call it, is very much fragmented. There's a CIDB which was given some powers and authority many years ago when they were founded, which was all very well intended. The same with the CBE. Sadly, what we saw during the COVID period, and I think that underlines the problem, is we saw many bodies formed as independent actually from those to get involved in the whole situation. And to make matters even worse is the fact that Treasury has got a higher say or status in the industry. You know, it comes back. My sentiment is from starting where Alison ended, is infrastructure, or whatever it wants to be called, should be briefly covered in the Public Procurement Bill, left to the industry to develop the details of itself, where all the aspects and the potential changes should be covered. You know, like I say, the CIDB's got some fantastic initiatives and documents. As an example, they have a requirement that once you go to tender, the project should proceed within a certain period of time. Now, if I look at public tenders going out at the moment, 2 of them in the very recent past had the validity extended 6 times over the last 2 years. I mean, the intention in the CIDB was that once the project goes to tender, it has been prioritized, it has been agreed by whoever needs to approve that budget, that it should proceed. What then is the reasons why it does not proceed to site? No excuses accepted in this instance, because the impact on the economy is devastating. Then the things that has materialized out of that, and I think it took the control from the CIDB, is items like these panels, which is now being started by most public entities. You know, is that because National Treasury's list is failing? Or is that because there's other intentions with regard to these panels? And, you know, I find it that some local entities in Gauteng are now excluding you if you weren't on that tender or on that panel from tenders. How can they? I mean, we're in a democracy where everybody should be given an opportunity, unless they only invite those panelists to do. So those things should ideally be under the watch of the CIDB, who should be empowered by resources and budget to do that. But we need to clarify, where does Department of Works come in? Because going back many years, you know, the Department of Public Works' role was to develop and oversee all of what we are talking now in the built environment.
Exactly.
All roads, all bridges, everything was supposed to be done and fall under them. And they would build the prisons, they would build the police stations, they would build the schools, all under them. But due to many reasons, and we can't change history, that has changed. So that power has been diluted from them. So we need to empower them again so that they take their rightful position in the economy. And then the CBE under them with regard to the CIDB, because to my mind, if we look at an organogram, public works should be at the top, government obviously above them, with all the entities related there, accounting and treasury, etc., playing their roles in DTI, and under them should be the CBE, which comprises all the expertise within the industry. And then under them, a direct arm to them, feeding daily almost the CIDB, so that they can be responsible for all procurement and procurement-related documentation and processes.
Good one, Frans.
A bit of a structure change needs to happen.
Good. Thank you. I'm going to ask Thandi to come in, and then we'll ask Alison to wrap up, and then I'm going to do the draw for the book. Hey, Thandi.
Hi, Sean. Good morning, colleagues. You know, Sean, I'm listening to this conversation about this whole infrastructure and building and whatever the two words that are used interchangeably. But I think what we need to be remember from a principal point of view, procurement, we tap in many different industries that have different dynamics in them. You know, for example, social development is another big spender. They work with charity organizations, they work with cooperatives. Department of Education is another spender. They work with publishers, they work with feeding schemes. You look at Department of Health, I mean, pharmaceutical companies that are producing medicine that has some intellectual property issues and all of that. And if you want to now, with this principle of saying, let's bring in a different body to govern a construction industry to some extent, then we are going back to the solution that this public procurement bill was bringing in terms of avoiding all these fragmented things that are all over the place about procurement, you know. And I think somebody said that we should not lose the principle that procurement is procurement, irrespective of what you are buying. So hence I'm saying that I think in this forum, maybe we do have more people who are coming from infrastructure environment. If we can bring people from health and education or social development in the podium and ask them to tell you about the dynamics that they're experiencing in their work environment, which somebody else, maybe even people from municipalities as well, because municipalities literally buy everything, you know. So I think we need to be very careful that the more we remain in that thinking, it's somehow going back to that thing that the more things change, the more they remain the same. So we might end up actually spending so much time trying to change things, but we're going back to that fragmented system of procurement. Thank you.
Thanks, Thandi. I see two people I'd love to ask some questions of, but let's ask Alison just to respond to those two comments first.
Right. So Thandi, I agree with you. There are always sector-specific rules, as there should be. There will always be, you know, nothing can be regulated in extreme detail. It's just not possible because industries and sectors have different needs. That's why we have, you know, your overarching legislation, your constitution, your overarching legislation, and then many entities have their own supply chain management rules as well. And I don't think that will necessarily go away, but I think what we're trying to emphasize is that that overarching legislation is problematic in construction, and that's the first step in correcting that. So getting that overarching regulation right, then we can have the more detailed, fleshed out rules that will be helpful in the sector. I don't really have a comment on France's input, except to say that I agree with much of what he's saying.
Thanks, Alison. Thank you. I was going to engage a little bit with Abigail, who's with the Gautrain Management Agency, and Angela, who spent some time at Sunrail. But you know what? we detracting a little bit. You've put a book out, and it's a really good resource. And I think that just wanted to encourage everybody, get to Juta's online website, place an order. For all of us who are in this space, it would be far better for all of us to just be as equipped as we can and as informed as we can based on what Alison has put together. It is, as she said, the first of its type. Alison, you are off to the US for a year. I hope that we could chat to you about infrastructure in the US. And
Lots
what's happening there
at the moment. Yeah.
And any insights you pick up and how that might help us here in South Africa, and if we can at some stage as well, maybe pick up on the lawfulness aspect of your contribution to the public, the administrative justice book. So
yeah, that would be great. I think actually the American system can really use some of what we're using here as well. So it goes both ways. But yes, I'd love to pick up that conversation.
Good one. Well, the university in Washington is going to be, it is Washington, hey?
George Washington University.
George Washington University is going to be privileged to have you there. And
thank you, Sean.
And well done to you. So all the best for your travels and for your year, and all the best with your book going forward. And thank you for your contribution today.
Thanks so much, and thanks for the opportunity. Much appreciated.
Thank you, everybody, for your inputs today. Working on two things for next week. One option is just to run through a summary of the recommendations in the Zondo Commission's report around procurement. But if we're able to organize it, we may have a couple of experts come in as well and give us their perspectives. So that's what we're working on. If that doesn't happen next week, it'll happen the week after. And yeah, so that's the focus. Very good, everybody. Thank you again, Alison. All the best to you. Keep safe, everybody.
Thank you, Sean.
Bye.
Bye.
Oh, hang on a sec. I said I must book. Okay, so what I've got here is a random number generator. I don't know if you can see this. You probably can't see that, but I've got and I'm going to now quickly generate, and it's number 14, and this is an easy thing.
Who is number 14?
Lois.
Number 14.
From the top, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. France. It's the second time that I've counted. And you get the book, France.